Harvey Weinstein won his appeal in the New York court, and he won based on the bad acts. The lawyer was author Aidala, who is the one that did the appeal for Harvey Weinstein in the New York case. So Arthur Aidala, Aidala, was the lawyer for the Weinstein appeal. And his argument was based on the bad act witnesses. He stated, under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior bad acts may not be admitted against them for the sole purpose of establishing their propensity for criminality. See People versus Molyneux. Nor may the prosecution use prior convictions or proof of the prior commission of specific criminal, vicious, or immoral acts other than to impeach the accused's credibility. It is our solemn duty to diligently guard these rights, regardless of the crime charged, the reputation of the accused, or the pressure to convict. It is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. And he went on to say, defendant was convicted by a jury for various sexual crimes against 3 named complainants, and on appeal claims that he was judged not on the conduct for which he was indicted, but on irrelevant, prejudicial, and untested allegations of prior bad acts. We conclude that the trial court erroneously admitted testimony of uncharged alleged prior sexual acts against persons other than the complainants of the underlying crimes. Because that testimony served no material, non-propensity purpose, the court compounded that error when it ruled that the defendant, who had no criminal history, could be cross-examined about those allegations, as well as numerous allegations of misconduct that portrayed defendant in a highly prejudicial light. The synergistic effect of these errors was not harmless. The only evidence against defendant was the complainant's testimony, and the result of the court's rulings, on the one hand, was to bolster their credibility and diminish defendant's character before the jury. On the other hand, the threat of a cross-examination highlighting these untested allegations undermined defendant's right to testify. The remedy for these egregious errors is a new trial. Thomas Farinella did preserve on the record his challenge to the bad acts witnesses in New York. It was in motions that he filed in a timely manner. It is preserved on the record. It was in the 5,000 pages of transcripts. Hopefully, the challenge to bad act witnesses was not left out of Robert Kelly's appellate brief, like the challenge to jury instructions was left out.